and welcome to the Newsenter. I'm Ritu Singh and Ashwin Kumar, my colleague, joins me from the Delhi studio as well. Now, the Supreme Court has taken away the bank's power to unilaterally declare accounts as fraudulent. The Apex Court has held that banks will now have to give a hearing to the borrowers before declaring them to be fraud. Now, we will be discussing the ramifications of this order in just a bit. But first, Ashwin Kumar, who's been tracking this case for us, gets us the highlights of the Supreme Court judgment.
A hugely significant order for the banking sector that affects the rights of borrowers as well as the concerns of lenders against default. So what is the Supreme Court judgment? What does it mean for the stakeholders? Well, at the heart of the issue is a 2016 circular issued by the RBI that armed banks to unilaterally declare accounts of willful defaulters as fraud. The Supreme Court has taken away that unilateral power, noting that it poses risks of arbitrary orders. So what exactly has the Supreme Court held? Well, in short, the Supreme Court has upheld the Telangana High Court judgment. The Supreme Court held that borrowers must be issued a notice and should be allowed a hearing before being declared as fraud. The Supreme Court holds that banks can't be allowed to exercise this power arbitrarily. The Supreme Court declared that principles of natural justice require that the affected party is given, at the very least, a hearing. But speaking of reasons, what are the Supreme Court's reasons behind stripping banks of this unilateral power? Well, the Supreme Court held that declaration of fraud by the bank has serious consequences, both penal as well as civil. Penal because the bank is required to file an FIR post-declaration of an account as fraud, and civil consequences because the declaration of fraud works like a blacklisting mechanism that bars the borrowers from accessing credit facilities. The Supreme Court has also made an addition to RBI's 2016 circular. The Supreme Court has now directed that banks will be required to record in their orders the reasons for declaring a particular borrower as fraudulent. The Supreme Court has hoped that this recording of reasons in the order will ensure that the banks don't exercise this power arbitrarily. Now, this should come as a setback to the RBI as well as to the banking system. The central bank had argued at length that this internal mechanism was required to act as an early warning system to alert other banks to risks posed by certain defaulters.
Ashwin, thanks very much for taking us through the details of that very important order. Now, to take this discussion forward, I'm joined by Mahesh Agarwal, who's the managing partner at Agarwal Law Associates, and Sunil Mehta, Chief Executive Officer of the Indian Banks Association. And of course, Ashwin stays with us. Gentlemen, thank you very much for joining us on the show today. Mr. Mehta, if I could start with you on how you read the order. If willful defaulters were given a chance to explain themselves, why not other borrowers as well who've been declared frauds? Or do you think this has taken away an important lever for banks?
Ritu, I would like to clarify this misconception. One thing is, as a banking system, we totally understand that the judgment of the Supreme Court is based on the principle of natural justice, and which must be applicable and should be available to all the citizens of the country. So perfectly fine. As regards to borrower fraud, it's not that the overnight banks go and declare it as a fraud. There is a system process which has been laid down by the regulator, and that regulator-driven process, there is a early warning signal. These early warning signals basically indicate that if there is a diversion of fund, or there is a misutilization of funds, or there is a siphoning of funds. So these early warning signals are generated. Based on the early warning signals, bankers do ask these questions to the borrower. What are these transactions, where this money is going on? And based on that, then they go and red flag the account into their books. Red flag means that the fraud signals are available. If it is a multiple banking account, if it is a consortium account, then that bank which has red flagged the account, it discusses it with all the members of the consortium that this is type of transactions we have observed in this particular account. And in the consortium, the borrower is also part of represent their case that yes, these are the transactions which has been observed as a say not a proper transaction, which can be fraudulent, or maybe in case the borrower is not able to explain. So informal opportunities are given to the borrower even today in the form of their clarifications on these transactions. Post this thing, when the banking system observes, yes, there is a fraud, then there is a proper forensic audit which is done by experts in forensic audit. They go for money trail, whether the money has gone, whether the money has been siphoned out of the system or not. And once it is established by the money trail, which is established through the forensic audit, then only the bankers go and declare it as a fraud. So saying this, that bankers were not having this, were having any consultation with the borrower, it do not happen, because borrower is regularly in touch with the banking system. Whenever a forensic audit is done, that is done on the books of the borrower. So borrower knows that forensic audit is being done. It means there is a suspicion on the part of the bank whether the money trail or the money is going into the proper purpose for which it has been lent. So
okay,
this,
Mr. Mehta?
just a minute.
Yeah.
So
Yeah, that is an important clarification. Yeah.
the system is
Continue, please
now,
continue.
This system is already in place. Only thing is, it is not documented in the form of a judicial process. Like right now, the bankers were discussing it with the borrower. They were giving it a scope to present their case into the consortium. Their books were audited by a special agency, which is the forensic auditor. So they are aware that bankers have appreciation, and they are given the opportunity to explain it. Where the difference is, now the bankers will have to document it properly. Like once they have identified all these things, they will give a notice. Okay, these are the transactions which have been found as a suspicion transaction, and based on the reply given by the borrower, they can document it, the reasons for difference from the reply given by the borrower, and then they can pass a final order also. Yes, these transactions were there. Borrower could not give a satisfactory explanation, and now this is to be created for. So only thing is, the process was in place, was not documented properly. So that will happen after the Supreme Court judgment.
Mr. Mehta, thank you very much for that detailed clarification. But I think the heart of the matter is that the Master Circular of 2016 does not expressly say, that the borrower must be given a chance to explain himself. But Mr. Agarwal, let me come to you as well, because at the heart of the matter again is the principle of natural justice, and the order also says that the decision or to declare the borrower as fraudulent should be made by a reasoned order. Now, who is to pass this order? A bank general manager, a bank's board? And if we're going about this principle of natural justice, will then lead to the borrower also having the right to appeal this order, which would have been passed by the bank?
See, this was a very critical correction which has been made by the Supreme Court. The reason is in 2016, when RBI gave a circular, this circular is binding on all banks. The option of the bank to not take action was taken away. So if the bank finds something wrong, they appoint a forensic auditor. The forensic auditor report comes to the bank, and they have no option but to immediately report to CBI. We have told the court that hundreds of cases have been filed in the last 2-3 years. Petitions have been filed in various courts, Gujarat, Delhi, Telangana, all over, by people saying that I have not been heard, no justification was sought, and basically on a basis of a report given by forensic auditor, grave civil consequences have been met. For example, a civil case has been filed, a person cannot deal with the bank, cannot borrow funds, he's completely blacklisted. So the consequences are so grave that was very necessary for a person to have a proper hearing. Now what will happen going forward is the bank will have to give a kind of a show cause notice to a borrower, place the forensic report in his hands, seek answers, give a hearing, and then take an informed decision. So the pressure of the RBI or the mandate of the RBI on the banks to take a action per force is taken away. Banks would also be at ease to take a logical, informed decision after hearing the borrowers. In case the borrower is thereafter aggrieved by any decision, if some justification is given, it's not taken into account by the bank, or some answers are not taken, of course the matter will go to court, but there will be at least some legitimate hearing, natural justice given before civil consequences are met by a borrower.
Sure. Mr. Agarwal, if I may come in, Ashmit here from the Delhi studio, if I may ask you a supplementary question, that as far as this particular issue, the Master Circular of 2016 is concerned, would you, from strictly a legal perspective, would it perhaps have been better for the Apex Court if it was unhappy with that 2016 circular, then simply to strike it down and then trust the wisdom of the RBI to come out with an alternate framework, rather than to go on and impose and amend and add more conditions to it, and the two conditions being, one, a hearing, and two, a reasoned order? Would it have been appropriate to leave the issue perhaps to not supplant the wisdom of the RBI?
No, I think what the Supreme Court has done is absolutely the right thing. To completely set aside the circular would have been a very grave step, because RBI ultimately is acting in public interest. they find that something has gone wrong and corrective actions have to be taken. So the RBI circular otherwise has been upheld. It's only the procedure which was faulty, and the procedure has been corrected. It would have been a lip service to quash the circular. RBI would have come with the same circular again. So what Supreme Court has done is has read clauses or provisions in the circular to validate the circular. The circular, which was otherwise illegal, has been legitimized by corrective measures which have been placed. So I think what the court has done is absolutely the right thing, to uphold the circular, give the power to RBI to give directions to the banks, and the banks must operate as per the circular in accordance with the directions given by the Supreme Court, i.e. to give natural justice.
Sure. Mr. Mehta, let me take this up with you. As far as these two additional compliances that are now imposed, one, a hearing will have to be given following a notice, and then two, the reasons will have to be clearly recorded. Let me ask you a two-part question. Number one, do you expect more litigation and that to perhaps slow down the entire defaulter recognition process, number one? And number two, is there an alternative of an interbanking communication exchange whereby some of these concerned suspicious accounts can be red flagged?
So I'll answer your first question first. The important is right now the opportunity that is given to the borrower is verbal and it is not documented. Once it is documented and it is there, yes, it can have a legal scrutiny and they can go to the court of the law. But that option was available earlier also. Like any citizen of the country can go against the order of a bank, even the RBI, and that's the way the people go and take the remedies. So these legal options are available. They were open to take those remedies even in the past, and now it is available again. Only difference is the documentation process, which was a missing link regarding giving a show cause notice, giving a proper reply in writing, and then passing an order. So the judicial process, because banks are now sitting on the judgment of declaring a person as a borrower, as a fraud or a willful defaulter, so they will document these processes. So that will be additional, empowerment to the system, because whenever it is challenged legally, this will now the declaration of fraud will be more sustainable because the due process has been observed. And I think it's a welcome step. I don't think it will derail any process or it will create any communication gap. As regards time frame, maybe 10-15 days time frame for a borrower, I think most of the banks first try to resolve these issues by understanding the transaction. So that's 10-15 days notice period which is given for understanding these issues and explanation. Maybe a little addition in the time, but it will satisfy the principle of natural justice. So I think banking system will not have any challenge into it.
Sure, Mr. Mehta. Thank you so much for that perspective and clarity on what this road ahead looks like post the Supreme Court verdict. Mr. Agarwal, thank you so much for sharing your thoughts and insights on explaining this landmark judgment and what it means for the stakeholders, especially the borrowers in this case. Gentlemen, thank you so much for joining us. With that, it's time now to slip into a very short break. But up next, mass protests in Israel over judicial reforms intensify after Prime Minister Netanyahu sacked his defense minister for opposing the overhaul. Details when we come back.